In this video, we are going to talk about what happens next after the Form I-130 has been approved. If you are overseas and you're waiting on this process, it could be very frustrating, especially if you don't know what to expect next, or if you are here in the United States, you might be wondering, well, how do I actually get the green card in my hands? Can I do adjustment of status? Well, I will be covering this issue in this video, so stay tuned. Visit us at Swat&Vee channel with your questions to see how best we can help you out with your process. Please don't forget to subscribe if you're new to this channel. Let's get into the video. Now let's talk about the Form I-130 process. Form I-130 is the underlying family petition filed by individuals who are filing for a spouse, parent, child, or sibling. Let's talk about those of you outside America. The question you need to ask yourself is my priority date current? Is it my turn? Has my turn come up yet for me to take further actions with this case? That's really critical, because if your priority date is not current yet, you really can't do much of anything right now. Once your case has been approved, the USCIS will send the case over to the National Visa Center, NVC. The NVC does what it calls a case creation, notification, or letter. It will send you a letter or an email notifying you that they have your case and there are some additional steps that you need to take in order to move the process forward. However, that case creation email or letter can be very confusing, because for many people, they actually can't do anything else right now. They actually have to wait because their priority date is not current yet. They are just being notified that the NVC has their case and that system online, the application process. The system is not opened up to you yet. You can't even pay your fees or anything, not until it's your turn. Your priority date has to come up first. If your priority date is not current, you will have to wait for the NVC to send you a second notification that it is now time for you to move forward with your visa application. If your priority date is current, oh, happy day, right? You can move forward and get things going at the NVC level. What happens if you are here in the United States? Should you apply for adjustment of status or not? Firstly, are you eligible to adjust your status? The big part that you need to really consider is this: am I an immediate relative of a US citizen, or am I in the family preference category? F1, F2, F3, or F4? Where am I? Because if you're an immediate relative of a US citizen, you may proceed now and apply for adjustment of status. And in fact, if you aren't an immediate relative, you should have filed the Form I-130 and Form I-45 applications together. It's much faster and easier to do that way. But in any event, if you're an immediate relative, you can go ahead and proceed with adjustment of status if you're eligible for adjustment of status. If you are in the family preference category, have I continuously maintained a lawful status in the United States all this time? If yes, then move on to the question, which is my priority date current? If your priority date is current and you've continuously maintained a lawful status, then you may proceed and apply for adjustment of status. But if your party date is not current and you have continuously maintained a lawful status, you have to continue to wait until your priority date becomes current. What happens if you have not continuously maintained a lawful status? You will not be able to apply for adjustment of status. What happens next is, again, you are going to go back to the question about whether your priority date is current. If it is current, then you are going to have to wait until your case goes over to the NVC and for them to notify you that they have your case, and then you're going to have to file a waiver, the Form I-601A waiver. You will need that waiver, but you cannot file that waiver too soon. If you file it too soon before case goes over to the NVC, that waiver application can be rejected by USCIS and they will send everything back to you, because it's not your turn yet to apply for that waiver. So your priority date must be current in order to apply for that waiver. Again, this is only for those of you with an approved Form I-130. The issue with the waiver can be a little tricky and confusing. So I'm going to summarize that point for you one more time. If you are here in the United States and you had not continuously maintained a lawful status and your priority date is current and your case is at the NVC level, then you may file the Form I-601A waiver. But if your priority date is not yet current and your case is not at the NVC level, you still have to wait before you can file that waiver. I hope this video was helpful to you. Please share this information with family and friends who may need it. You can also help us spread the message by sharing it on all social media. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!